I was refinancing. Routine. Better rates, updated valuations. The same paperwork I'd done twice before on the Vance Family Land Trust holdings. The title examiner called on a Tuesday morning in February. His voice had the careful quality of someone who has found something unexpected and is choosing his words before he delivers it. Ms. Vance, I'm running the search on the Pinecrest Commons parcel, the 1,800-acre holding. Go ahead. There's a recorded deed transfer on that property. October 14th, 2022. I stopped what I was doing. Read it to me. The grantor was the Pinecrest Commons HOA. The grantee was Creston Land Partners, LLC. Consideration stated, $2.3 million. Signed by Mitchell Greer, HOA president. My family has owned that land since 1951. My grandfather bought it with 20 years of savings and a loan from the 8th bank he walked into. 7 had said no. He recorded the deed on April 3rd, 1951, in Harmon County, Georgia. It passed to my father, from my father to me, into the Vance Family Land Trust, where it had sat, recorded and unambiguous, for 73 years. Mitchell Greer had spent 9 years as president of the 220-home community built on that land. Creston Land Partners, LLC was owned by his son, incorporated 11 months before the deed was recorded. The $2.3 million was never paid. He recorded a fraudulent deed on my family's property, tried to sell 340 acres of it to a commercial developer for $8.4 million, failed when a title examiner did his job, and spent the next 18 months in silence. He thought I wasn't looking. I spent 40 years as a real estate attorney. I was looking. Before we start, tell me where you're listening from today, and if you're enjoying the content, hit like and subscribe for more stories just like this. The call came on a Tuesday morning in February. I was in my Atlanta office, the same office I'd occupied for 22 years on the 14th floor of a midtown building with a view of Piedmont Park through the east window. The park was bare in February, the trees stripped to their architecture, the light flat and white the way Atlanta light gets in winter when the sky can't decide between cloud and sun. I'd been a real estate attorney for 40 years. I'd retired from active practice in 2021, but kept the office for trust work. The Vance Family Land Trust required ongoing management, and I preferred to do it from a place that felt like work, rather than from my kitchen table. The refinancing package had been straightforward up to that point. The trust held several parcels across 3 Georgia counties. The refinancing was a routine exercise. Better rates, updated valuations, standard documentation. I'd done it twice before, in 2011 and in 2016. The title company I used had handled Vance Trust work for 15 years. They knew the holdings, knew the chain of title, knew what clean looked like, which is why the call was unusual. Ms. Vance. It was Thomas Reed, the senior title examiner. His voice had the careful quality of someone who has found something unexpected and is choosing his words before he delivers it. I'm running the ownership search on the Pinecrest Commons parcel, the 1,800-acre holding. Go ahead. There's a recorded deed transfer on that property, recorded October 14th, 2022, in Harmon County. I stopped what I was doing. Read it to me. The grantor is listed as Pinecrest Commons Community Association. The grantee is Creston Land Partners, LLC. Consideration stated is $2.3 million. The deed is signed by a Mitchell A. Greer as authorized representative of the Pinecrest Commons Community Association. A pause. Ms. Vance, I've reviewed the Vance Family Land Trust chain of title going back to 1951. The trust has held fee simple title to this parcel continuously. The Pinecrest Commons Community Association does not appear anywhere in the chain of title as an owner. The office was very quiet. Send it to me. Everything. The deed, the notary certification, the recording page, all of it. Sending now. I ended the call and waited. The document arrived in my email in 4 minutes. I opened it on my desktop and expanded it to full screen. 12 pages. The deed itself was on pages 1 through 4. Standard Georgia warranty deed format. Correctly structured, correctly captioned. Grantor, Pinecrest Commons Community Association, a Georgia nonprofit corporation. Grantee, Creston Land Partners, LLC, a Georgia limited liability company. Property description. 1,800 acres, more or less, Harmon County, Georgia. as described in the attached survey exhibit. Consideration: $2,300,000. $2,300,000. I read the property description. It was my land. The meets and bounds description matched the Vance family land trust parcel exactly. The same boundaries my grandfather had recorded in 1951. The same survey lines that had appeared in every subsequent deed and tax record for 73 years. Page 5. The notary certification. Signed and sealed by a notary public in Augusta, Georgia. Dated October 12, 2022. Page 6. The recording clerk's stamp. Harmon County Superior Court. Clerk of Superior Court. Recorded October 14, 2022. Deed Book 847. Page 223. Pages 7 through 10. The survey exhibit. Pages 11 and 12. The signature page. I looked at the signature page for a long time. Mitchell A. Greer. Signed in blue ink, in the confident cursive of a man who was used to signing documents and expected them to mean what he intended. Below his signature, his printed name and title: President, Pinecrest Commons Community Association. A witness signature. A notary seal. Everything formally correct except for the one fact that made all of it meaningless. Mitchell Greer didn't own this land. The Pinecrest Commons Community Association didn't own this land. They had never owned this land. My grandfather, Raymond Vance Sr., had purchased 1,800 acres of Harmon County farmland in the spring of 1951. He'd paid $47,000 for it, money saved over 20 years of farming, supplemented by a loan from a black-owned bank in Atlanta that had been willing to finance what 7 white-owned banks had refused. The deed had been recorded in Harmon County on April 3, 1951. In 1989, my father had negotiated a ground lease development agreement with Harold Stern, a residential developer who wanted to build a planned community on a portion of the acreage. The agreement was clear. Stern could build homes, sell the structures, collect his profit from the residential sales. The land stayed in the Vance family land trust, perpetually. Ground rent paid annually to the trust, no ownership transferred. Pinecrest Commons was built on that land. 220 homes, a clubhouse, common areas, roads, a small park, all of it on Vance family land trust property. The HOA had been formed in 1991. It had operated for 33 years on land it had never owned, and to my knowledge, had never been told it owned, until Mitchell Greer signed a deed saying otherwise. I sat with the document for 1 hour. I did not call the HOA. I did not call my attorney. I did not call Thomas Reed back. I sat in my office on the 14th floor with the park bare and gray outside my window, and I read every page of the document 3 times. I read the deed language. I read the property description. I read the notary certification and check the notary's commission number against the Georgia Secretary of State's notary database. The commission was valid. The notary was real, which meant someone had physically appeared before a notary in Augusta on October 12, 2022, and executed this document in person. I read the recording clerk's stamp. October 14, 2022, Harmon County. Deed Book 847, page 223. For 18 months, a fraudulent deed claiming ownership of my family's land had been sitting in the Harmon County public record. I had not known. I tried to reconstruct the 18 months in my mind. The trust had been operating normally, ground rent payments coming in, tax bills going to the correct address, no correspondence from Harmon County about any change in ownership. The fraudulent deed had been recorded without triggering any of the standard notifications that a legitimate title transfer would generate, because there was no title insurance claim, no mortgage lender notification, no transfer tax payment corresponding to a $2.3 million transaction. Someone had filed this deed as quietly as possible. Someone had been counting on me not looking. I looked at Mitchell Greer's signature one more time. Then I picked up the phone. Catherine Osei had been a property litigation specialist in Atlanta for 18 years. I'd known her for 12. She'd clerked for a judge whose chambers I'd appeared before regularly, and we'd stayed in professional contact after she entered private practice. She was precise, thorough, and had a particular gift for the kind of patient, methodical litigation that property fraud cases required. She answered on the second ring. "Eleanor, what's wrong?" She knew my voice well enough to hear it. "Catherine, Someone recorded a fraudulent deed on the Vance Trust property, the Pinecrest Commons parcel, 1,800 acres. I kept my voice level. I need you to pull everything. Corporate records on the grantee, Creston Land Partners LLC Georgia registration, full financial history of the Pinecrest Commons HOA for the past 4 years. And I need a title examiner's affidavit confirming the Vance Trust chain of title going back to 1951. A brief silence. How fraudulent. The HOA doesn't own the land. They've never owned the land. Mitchell Greer signed a deed as HOA president, conveying 1,800 acres of my family's property to a Georgia LLC for $2.3 million. Another silence. Longer. I'm pulling the Harmon County records now. I heard her keyboard. Eleanor, this deed, was it recorded with a closing statement, title insurance? No closing statement in the filing. No title insurance stamp. No transfer tax receipt corresponding to a $2.3 million transaction. So he recorded a deed with no real closing. He recorded a deed with no real closing, no legitimate title, no ownership to convey, and no money that I can find moving through any account associated with either entity. Catherine was quiet for a moment, with the specific quality of an attorney processing the dimensions of something. Who is Mitchell Greer? HOA president. Has been for 9 years. Commercial broker. And Creston Land Partners? I don't know yet. That's what I need you to find. I'll have preliminary corporate records within the hour. Eleanor. She paused. This is deed fraud on recorded title. Georgia Code Section 44-2-1 et sec. It's a felony. I know what it is. How do you want to proceed? I looked at the signature page on my screen. Mitchell Greer's blue ink signature on a document claiming to convey what my grandfather had purchased in 1951, with 20 years of savings and the one bank in Georgia that had been willing to say yes. Quietly, I said, I want everything documented before I make a single move. I want the full picture. Who Creston Land Partners is, where the money went, what Mitchell Greer was planning to do with a fraudulent deed to 1,800 acres of someone else's land. I want it all before he knows I've found it. That's smart. Catherine. He sold my family's land. My voice stayed even. I'd spent 40 years keeping my voice even in rooms where I was the only person who looked like me, and the stakes were always higher for me than for anyone else at the table. I want him to understand exactly what he sold, and exactly what that means. I'll call you in an hour. I ended the call and looked out the window. The park was bare and gray and still. My grandfather had bought this land in 1951. He'd been told no by 7 banks. He'd found the 8th. He'd signed a deed in Harmon County on a spring morning, 73 years ago, and that deed had passed to my father, and from my father to me, and from me into the Vance Family Land Trust, where it had sat, recorded and unambiguous and absolute, for longer than Mitchell Greer had been alive. He'd sold my family's land. He'd signed a deed in blue ink and walked into a notary's office in Augusta and handed someone a document conveying 1,800 acres he'd never owned to a company I'd never heard of for $2.3 million that had never been paid. He had no idea I was coming. He had no idea what was already in motion. He had no idea who owned the land he was standing on. He was about to find out. Catherine called back in 53 minutes. I'd spent the interval doing what I always did when I was waiting on information that would determine the shape of what came next, reviewing the underlying documents. Not the fraudulent deed. I'd read that enough times. I was reviewing the original 1989 ground lease development agreement between the Vance Family Land Trust and Harold Stern, the developer who'd built Pinecrest Commons. The agreement was 34 pages. I'd reviewed it when I inherited the trust in 2018 and again in 2021 when I'd retired and taken over active management. The language was clear throughout. The trust conveyed no ownership interest to Stern or to any successor entity. The land remained trust property in perpetuity. Ground rent payments ran to the trust at fixed annual rates with escalation provisions. Any HOA formed by the residential community would derive its authority from the homeowner's individual ground lease agreements, not from any ownership interest in the underlying land. The HOA owned nothing. It had never owned anything. It had authority over the residential structures and the community governance within the development. It had no authority over the land those structures sat on. The land was mine, Had been mine since 2018. Had been my father's before that. Had been my grandfather's before that. Since April 3rd, 1951. I have the corporate records, Catherine said when she called. Creston Land Partners, LLC, Georgia Secretary of State. Registration date, November 18th, 2021. I noted the date, 11 months before the fraudulent deed was recorded. Registered agent? Whitmore & Associates, a law firm in Augusta. I've pulled their client list. They handle corporate formation and basic commercial work. Nothing sophisticated. Standard registered agent service. She paused. Single member LLC. The member is listed on the operating agreement filed with the Secretary of State. Who is it? Derek Allen Greer. Date of birth puts him at 34 years old. A pause. Eleanor, I ran the name. Derek Greer is Mitchell Greer's son. The office was very quiet. His son incorporated Creston Land Partners, LLC, 11 months before his father recorded a deed transferring 1,800 acres of your family's land to that company. Catherine's voice had the particular evenness of an attorney delivering information she wants on the record, precisely as stated. The timing is not ambiguous. I let that sit for a moment. Mitchell Greer had spent 9 years as HOA president of a community built on my family's land. He'd been telling his community, according to what I'd later pieced together from various sources, that he was working on the land situation, a phrase vague enough to mean anything, deployed specifically to mean nothing concrete, while creating the impression of forward motion. In November 2021, he'd had his son incorporate a shell company. In October 2022, he'd signed a deed transferring 1,800 acres of Vance Family Land Trust property to that shell company, recording it in Harmon County as a $2.3 million transaction. The purchase price, I said. Was any money paid? That's the second thing I found. I pulled every financial record I could access for both entities, Creston Land Partners and the Pinecrest Commons HOA, going back to January 2021. I also ran a general financial search on Mitchell Greer personally through the public records we can access without subpoena. She paused. Eleanor, the $2.3 million stated on the deed was never paid. No wire transfer, no cashier's check, no mortgage, no financing statement, no closing statement on file anywhere, no title insurance policy issued, which any legitimate buyer would require on a $2.3 million land purchase. No survey ordered for the transaction. He recorded a deed with no closing. No consideration, and no legitimate title to convey. The $2.3 million figure on the deed is what Georgia law calls false consideration, a stated price with no corresponding payment. It's a standard element of fraudulent deed transactions. You state a price to make the document look legitimate. You don't actually pay it. I thought about that. Mitchell had recorded a deed on my family's land, transferring it to his son's company for money that was never paid. The deed was fraudulent on its face. The HOA had no title to convey. But even if one were to set aside the ownership question, the transaction itself was a fiction. No closing, no money, no legitimate real estate process of any kind. What was he planning to do with it? I asked. That's the third thing. I heard papers moving. I found a development proposal. It took some digging. It wasn't in any public filing. I found it through a contact at a regional commercial real estate database who had it logged as a dead transaction. Tell me. In February 2023, 4 months after the fraudulent deed was recorded, Creston Land Partners LLC approached a commercial developer called Apex Growth Partners. Apex is a mid-size firm based in Savannah. They do mixed-use developments, retail corridors, that kind of work. Creston's proposal was for a 340-acre mixed-use commercial corridor on the northern section of the Pinecrest Commons land. Retail, residential density, a hotel component. The proposal valued the 340 acres at approximately $8.4 million. I did the arithmetic without effort. Mitchell had recorded a fraudulent deed transferring 1,800 acres to his son's company for $2.3 million in stated and unpaid consideration. He'd then tried to sell 340 of those acres to a commercial developer for $8.4 million. The profit on the scheme, if it had worked, would have been approximately $8.4 million for a transaction that had cost him nothing because he'd never paid for the land he was selling. What happened with Apex? They did their standard due diligence, requested title verification. A title examiner reviews the chain of ownership before any commercial developer commits to a land acquisition. The title examiner pulled the Harmon County records. Catherine paused. Eleanor, the Vance family land trust chain of title is so clean and so well documented that the problem would have been obvious to any competent title examiner within 20 minutes of pulling the records. The 1951 recording, the 1989 ground lease development agreement, the trust transfer in 2018, the annual ground rent payments. None of it was consistent with the HOA owning the land. The deal fell through. The deal fell through in mid-2023 when Apex's title examiner flagged the chain of title problems, and Apex quietly withdrew. No lawsuit, no public filing. Commercial developers don't publicize failed acquisitions when the failure involves a title that looks fraudulent. They just walk away and move on. And Creston Land Partners? Dormant since the Apex deal died. No filings, no activity, no registered agent renewal coming up. They'll likely be administratively dissolved by the Secretary of State within the year if nothing changes. She paused. But the deed is still recorded. Mitchell's fraudulent transfer is still sitting in Harmon County Deed Book 847, page 223. He recorded it, the deal fell through, and he apparently decided that leaving the fraudulent deed on record was less risky than trying to unwind it. He'd been wrong about that. The HOA financials, I said. What happened to the $2.3 million? Nothing happened to it because it was never paid. But I pulled 3 years of HOA financial records. They're available under Georgia HOA disclosure requirements. The operating budget, the reserve fund, the bank statements. And the $2.3 million appears nowhere. Not in any HOA account, not as a line item in any budget, not as any form of income or asset. The HOA's financial records show no knowledge of the transaction whatsoever. She paused. Which means either Mitchell conducted this entire scheme without the knowledge of his board and his community, which is what the financial records suggest, or the board knew and kept it entirely off the books. What does the meeting minutes show? I pulled 3 years of minutes. There is one reference, a single line in the October 2022 board meeting minutes. President Greer reported ongoing progress on the community land status resolution. Details to follow at a future meeting. No vote. No discussion. No disclosure of a deed transfer, a shell company, a $2.3 million transaction, or any of the specifics. She paused. Details never followed at a future meeting. The subject doesn't appear again in any subsequent minutes. I set down the pen I'd been holding. 220 households in Pinecrest Commons. Families who'd purchased their homes in good faith, paid their mortgages, paid their HOA dues, attended community meetings, trusted their HOA president to tell them the truth about the land they lived on. For 2 years, a fraudulent deed to that land had been sitting in the public record. Their HOA president had recorded it, tried to sell the land through his son's company, failed, and said nothing to anyone. He'd told them he was working on the land situation. He had been, just not the way any of them had imagined. Catherine. I kept my voice even. What's the full picture? Mitchell Greer used his position as HOA president to record a fraudulent deed on your family's land, transferring it to his son's company, and then tried to sell it to a commercial developer. The deal fell through because the title was obviously fraudulent. The fraudulent deed is still recorded, and 220 families have been living on your land for 2 years, thinking Mitchell was handling the land situation. I looked out the window. The park was still bare. The light was still flat. The city moved below the 14th floor with the ordinary indifference of a place that didn't know what had just been laid out on my desk. He was handling it, I said, just not the way they thought. Catherine was quiet for a moment. How do you want to proceed? I thought about the sequence. In 40 years of real estate law, I'd learned that the order of moves mattered as much as the moves themselves. What you filed first determined what options remained. What you disclosed and when shaped the entire downstream of the case. I want the full chain documented before we file anything. Corporate records certified. Title examiner affidavit covering the full chain from 1951 through present. HOA financial records forensically reviewed. I want to know if there's any money trail we're missing, even if it doesn't show in the standard records. And I want a complete profile on Derek Greer, not just the LLC registration. His financial history, his professional background, any other entities he's associated with. That's 2 weeks of work. Take 3 if you need it. I've waited 18 months without knowing. I can wait 3 more weeks knowing everything. And Mitchell doesn't know you found it. Mitchell has no idea. I looked at the fraudulent deed on my screen one more time. He recorded this in October 2022 and nothing happened. He tried to sell it in early 2023 and the deal quietly died. He spent the last year assuming the problem went away. The problem didn't go away. No, I said. The problem just learned who owned the land. Catherine filed on a Monday morning in March. 3 weeks of preparation had produced a filing that was, by any measure, among the cleaner, quiet title actions I'd seen in 40 years of practice. The documentation was complete, sequential, and unambiguous. The Vance family land trust chain of title ran in an unbroken line from April 3, 1951, through the present day. Every transfer recorded, every instrument certified, every tax payment documented. The title examiner's affidavit covered 73 years of ownership history in 31 pages, and arrived at one conclusion stated in the final paragraph, with the flat certainty of someone who has reviewed the same fact from every possible angle. The Vance family land trust is, and has been, at all relevant times, the sole fee simple owner of the 1,800-acre Pinecrest Commons parcel in Harmon County, Georgia. No other party has held or currently holds any ownership interest in this property. The quiet title action had 2 requests. First, a judicial declaration that the deed recorded October 14, 2022, in Harmon County Deed Book 847, page 223, purporting to convey the Pinecrest Commons parcel from the Pinecrest Commons Community Association to Creston Land Partners, LLC, was void ab initio, void from its inception, as if it had never existed, because the grantor had no title to convey. Under Georgia law, a deed conveying property the grantor does not own is not voidable. It is void, not a defective transfer that can be cured or challenged on equitable grounds. Void, a legal nullity. The deed had never transferred anything because there was nothing to transfer. The HOA had no ownership, and you cannot convey what you don't have. Second, an order directing the Harmon County Clerk of Superior Court to expunge the fraudulent deed from the public record and annotate Deed Book 847 to reflect that the October 14, 2022 entry was void and without legal effect. The criminal referral went to the Georgia Attorney General's office simultaneously. Catherine had prepared it carefully. 47 pages. Georgia Code Section 16-9-1, forgery in the first degree, for executing a deed with intent to defraud. Georgia Code Section 16-8-3, theft by deception, for attempting to obtain property by creating false impressions of fact. Federal wire fraud, for the electronic communications involved in the Apex Growth Partners development proposal. The referral included the full corporate record of Creston Land Partners, the timeline of the Apex transaction, the HOA meeting minutes, and the title chain documentation. It was, Catherine told me when she sent me the filing confirmation, the most thoroughly documented criminal referral she'd submitted in 18 years of practice. The AG's office will move on this, she said. Deed fraud on recorded title with a documented attempt to sell to a third party. That's not a close call. Good. The termination notices go out today? Today. The termination notices went out by certified mail on Monday afternoon, the same day as the court filing, the same day as the AG referral. 5 of them. Mitchell Greer, 14 Pinecrest Commons Boulevard, and 4 board members whose names had appeared in the HOA resolution Catherine had found buried in the October 2022 meeting minutes, a resolution authorizing the HOA president to execute documents necessary to resolve the community land status matter. 4 signatures on that resolution. 4 board members who had voted to authorize whatever Mitchell had told them he was doing with the land. Whether they'd understood the full scope of what they were authorizing was a question the AG's investigation would eventually answer. For the purpose of the termination notices, the authorization was the relevant fact. The notices cited Section 14 of the Standard Pinecrest Commons ground lease, the material breach provision, two specific breaches. First, authorizing and executing a deed purporting to convey ground lessor property without the ground lessor's knowledge, consent, or authorization. The ground lease was explicit. Lessees had no right to convey, encumber, or take any legal action affecting the ground lessor's title without written permission. Second, participating in an attempt to sell ground lessor property to a third party for commercial development, constituting willful interference with the ground lessor's ownership rights. The notice is closed with the standard language. This was not a formal termination. It was a notice of review and intent. Recipients were advised to consult an attorney within 21 days. I sent them knowing what would happen next. Mitchell's attorney called Catherine on Wednesday. I wasn't on that call. Catherine briefed me afterward. His attorney is a man named Robert Finch, commercial litigator out of Augusta. He called wanting to know the basis for the termination notices and whether Ms. Vance would be willing to discuss a resolution. What did you tell him? I told him the basis was fully documented in the notices themselves and in the quiet title filing, which is public record, and I told him that Ms. Vance would be happy to speak with his client directly if Mr. Greer wished to request that conversation. Mitchell called me on Thursday. I was in my office. The park outside had the first suggestions of spring, a faint green haze in the tree line, the light coming at a slightly different angle than it had in February. I'd been expecting the call since Monday. I'd prepared for it the way I prepared for every significant conversation in 40 years of legal practice, by knowing exactly what I was going to say and exactly what I wasn't. Ms. Vance, his voice was controlled, the voice of a man who'd spent 9 years running a community association and was accustomed to for several years, and the 2022 for several years, and the 2022 transaction was part of that process. Mr. Greer, my voice was even, not cold, precise. There's no misunderstanding. You recorded a deed in Harmon County in October 2022, transferring 1,800 acres of Vance Family Land Trust property to Creston Land Partners, LLC. You signed that deed as HOA president. Creston Land Partners, LLC is a single-member LLC whose sole member is your son, Derek Greer. The Vance Family Land Trust has held fee simple title to that property since 1951. The HOA has never held any ownership interest in the land. A pause. The HOA has been managing this community. You have been managing the residential community built on my family's land, under ground lease agreements that give you governance authority over the structures and common areas within the development. Those agreements give you no ownership interest in the underlying land, and no authority to convey it, encumber it, or take any legal action affecting the trust's title. We have community rights that predate your involvement with this property. The ground lease development agreement was executed in 1989 between Harold Stern and the Vance Family Land Trust. The trust's ownership predates that agreement by 38 years. Your community's rights derive entirely from that agreement and from the individual ground leases your homeowners hold. None of those documents give the HOA ownership of the land. Another pause. Longer. Ms. Vance, you can't terminate our leases. We're homeowners. People have mortgages. Families live here. You own your structure, I said. The building, the improvements, the personal property within. I own the land your structure sits on. That has been true since the day your home was built. The ground lease termination notices were sent to you and 4 board members specifically because you authorized and executed a deed attempting to convey my family's property. That is a material breach of your ground lease. Those people had no idea what they were authorizing. They signed a board resolution authorizing the HOA president to execute documents to resolve the community land status matter. Whatever they understood that to mean, their signatures are on the authorization. My attorney has the minutes. A longer silence. You're doing this because we didn't consult you. We should have consulted you. I understand that now. But the community had been operating for 30 years without any active communication from the trust, and we were trying to stabilize the land situation by recording a deed to your son's shell company. The silence that followed was different from the others. not the silence of someone choosing words, the silence of someone whose prepared narrative has encountered a fact it can't accommodate. Mr. Greer, I kept my voice level. I've been a real estate attorney for 40 years. I've reviewed thousands of property transactions. I know what a fraudulent deed looks like. I know what a shell company incorporated 11 months before a fraudulent recording looks like. I know what an attempt to sell fraudulently acquired land to a commercial developer looks like. I have all of it documented. My attorney has filed a quiet title action in Harmon County Superior Court. My attorney has filed a criminal referral with the Georgia Attorney General's office. A pause. I'll fight this, he said, not with the authority he'd started the call with something more reflexive, the statement of a man who didn't have a plan, but needed to say something that wasn't surrender. Mr. Greer, I looked out at the park, the green haze in the trees, the spring light finding its angle. I've been waiting 18 months to have this conversation. In that time, I've documented every element of what you did, why you did it, and what you attempted to do with my family's land. I have the deed. I have the corporate records. I have the Apex Growth Partners development proposal. I have your board resolution. I have the financial records showing the $2.3 million was never paid. I paused. Please fight it. I ended the call. He called Robert Finch immediately. I know what was said in that call because Finch called Catherine the following morning, not to negotiate, but because he'd spent Thursday evening pulling the Vance family land trust records from the Harmon County filing system and had arrived at a conclusion that apparently required an immediate conversation. Catherine told me about it Friday morning. Finch called at 8:15 a.m. He said, and I'm quoting him directly, "I need to understand who Eleanor Vance is and what her actual ownership position is on this property." I sent him the title chain, the 1951 recording, the 1989 ground lease agreement, the 2018 trust transfer, all of it. How long did it take him to call back? 40 minutes. What did he say? Catherine paused. And in that pause, I could hear the specific quality of an attorney who was about to deliver a line she's been looking forward to since Monday. He said he needed to advise his client that the Vance family land trust appeared to hold clear fee-simple title to the entire Pinecrest Commons parcel, and that his client should understand the full implications of that ownership position. She paused again. And then he asked me, quietly, not as a formal inquiry, "How long has Ms. Vance owned this property?" What did you tell him? I told him Ms. Vance inherited the trust in 2018, but that the Vance family has owned the land since 1951. Another pause. There was a silence on his end. Then he said he'd need to speak with his client before any further communication. I thought about Mitchell Greer in that conversation. 9 years as HOA president, 30 years of his community built on land he'd apparently decided, at some point, that he could claim. 11 months planning a scheme with his son. A deed recorded in October 2022 that he'd apparently believed would go unnoticed or unchallenged. A development proposal that had quietly died. 18 months of silence that he'd apparently mistaken for safety. And now Robert Finch telling him that the woman on the other end of Thursday's phone call had owned the land since 2018, and that her family had owned it since 1951, and that her title was so clean it would survive any legal challenge he could construct. I could imagine the question forming. Who is she? And Finch, having spent 40 minutes with the Harmon County records and the trust documents, giving him the only accurate answer. She's your landlord. Has been since 1989, and her family owned that land since 1951. I sat with that for a moment. Then I called Catherine. The quiet title hearing. When is Judge Harrison scheduling it? Preliminary hearing is set for April 22nd. He reviewed the filing and the criminal referral went to the AG the same day, so he's treating it as an expedited matter. Good. And the termination notice response period? 21 days from Monday's delivery, runs through April 1st. When that period expires without a response, I want to move immediately to the next step, the ground lesser position sale. Yes. Catherine was quiet for a moment. Eleanor, when you sell the ground lesser position on Mitchell's lot, you understand what that does to his mortgage. I understand exactly what it does. His lender holds a mortgage on a structure. The structure sits on a ground lease. If the ground lease is terminated and the ground lesser position is sold to an enforcement firm, the collateral changes. The lender's security is no longer a home on a lot. It's a structure with no legal right to occupy the land beneath it. I looked out the window. The park was fully green now in the early spring light. Mitchell Greer recorded a deed on my family's land and tried to sell it to a developer. I'm going to sell the land beneath his feet to someone who knows exactly what to do with it. That's a significant move. He made a significant move first. The 21-day response period expired on April 1st. No response from Mitchell Greer. No response from any of the 4 board members. Robert Finch had filed a notice of appearance in the quiet title action and submitted a single motion, a request for additional time to respond to the termination notices, citing the complexity of the property issues involved. Catherine had opposed it. Judge Harrison had denied it. The termination notices stood. The response period had run. The material breach findings were operative. I called Catherine on the morning of April 2nd. Moved to the next step. The transaction with Meridian Land Capital had been in preparation for 3 weeks, since the day I'd told Catherine that selling the ground lesser position was the appropriate next move. I'd contacted Meridian directly. I'd worked with their principal before, a decade ago, on a distressed ground lease situation in Fulton County. They were precise, aggressive in the way that specialized investment firms are aggressive, not theatrical, not punitive for its own sake, but absolutely committed to extracting the full legal and financial value of whatever position they held, which was exactly what this situation required. Meridian's business model was straightforward. They identified ground lease positions where the lessee was in breach, delinquent, or otherwise compromised, situations where the ground lessor wanted liquidity rather than the extended process of enforcement, and they purchased those positions at a negotiated price. Then they enforced them, aggressively, methodically, through every legal channel available. The negotiation had taken 4 days, 5 ground lease positions, Mitchell Greer's lot at 14 Pinecrest Commons Boulevard, and the 4 board members' lots. All 5 in documented material breach. All 5 with termination notices outstanding. All 5 with lessees who had, so far, declined to respond or negotiate. Meridian's offer, $340,000 for all 5 positions. The calculation was straightforward from their side. 5 residential lots in a developed community. Ground rent income during any period before termination was executed. Potential recovery from enforcement proceedings. The possibility that one or more of the 5 lessees would negotiate rather than face termination, paying a premium to cure the breach and establish a new lease on Meridian's terms. From my side, the calculation was equally straightforward. I was giving up the long-term ground rent income on 5 lots, not a significant financial sacrifice given the trust's overall holdings. What I was gaining was the certainty and speed of enforcement by a firm that did nothing else, and I was sending a message to Mitchell Greer that was considerably more direct than anything a letter from Catherine's office could deliver. The assignment agreement was signed April 3rd, 73 years to the day from the date my grandfather had recorded his deed in Harmon County. I hadn't planned that alignment, but when Catherine mentioned the date while we were finalizing the paperwork, I noted it and said nothing. Some coincidences are worth acknowledging quietly. Meridian's notification letters went out April 4th. Each of the 5 recipients received a certified letter on Meridian Land Capital letterhead. The letter stated that effective April 3rd, 2024, the ground lesser interest for their residential lot in Pinecrest Commons had been assigned by the Vance Family Land Trust to Meridian Land Capital LLC. All future ground rent payments were to be remitted to Meridian. All lease communications were to be directed to Meridian's legal department. The letter also noted, in the final paragraph, that the recipient's ground lease was currently in a state of noticed material breach, and that Meridian Land Capital had assumed the position as ground lessor with full knowledge of that breach, and full intention of exercising all available remedies under the lease terms and Georgia law. Mitchell received his letter on April 5th. He called Robert Finch within the hour. I know the substance of that conversation because Finch called Catherine the same afternoon, not to negotiate, not to request anything formally, but with the particular quality of an attorney who needs to confirm that what his client is telling him is actually what has happened. He called to verify the assignment, Catherine told me. He wanted to confirm that the Vance Family Land Trust had actually transferred the ground lesser position on Greer's lot to a third party. What did you tell him? I told him the assignment agreement was executed April 3rd, recorded in Harmon County April 4th, and that Meridian Land Capital is now the ground lessor of record for the 5 affected lots. I sent him the recorded assignment document. How long before he called back? 35 minutes. What did he say? He said his client was very concerned about the implications for his mortgage and wanted to understand his options. She paused. I told him his client's options were to engage directly with Meridian Land Capital regarding the material breach and work toward a negotiated resolution, or to face the full enforcement process. I also told him that Meridian's involvement didn't change the underlying quiet title action or the AG criminal referral. Those proceed on their own track, regardless of who holds the ground lessor position. The community notice went out the same week. Catherine had drafted it carefully. A formal notice filed with the Pinecrest Commons HOA's official records and distributed to all 220 households. It was 4 pages, plain language, no legal jargon beyond what was necessary. The first page explained, for the first time in clear and direct terms, the ground lease structure of Pinecrest Commons, that the community had been built in 1989 on land owned by the Vance Family Land Trust, that every homeowner in Pinecrest Commons owned their structure, the building, the improvements, but not the land, that the land had been owned by the Vance family since 1951 and remained so. The second page explained the fraudulent deed, that in October 2022, HOA President Mitchell Greer had recorded a deed in Harmon County purporting to transfer 1,800 acres of Vance Family Land Trust property to Creston Land Partners, LLC, a company owned by his son, that the deed was fraudulent, that the HOA had no title to convey, and that a quiet title action had been filed in Harmon County Superior Court to expunge it from the record. The third page was the one that mattered most to 215 of the 220 households. The ground lease termination notices and the ground lessor position sale applied only to Mitchell Greer and the 4 board members who had signed the HOA resolution authorizing the land transaction. The remaining 215 households were not in breach. Their leases were in good standing. Their homes were not affected by the enforcement proceedings. The fourth page introduced Eleanor Vance, the trust's beneficiary and trustee, and stated her intention to establish direct, transparent communication with the Pinecrest Commons community going forward. The community meeting was called for April 15th. I attended. It was the first time most of the 220 households had ever seen me. I'd been in abstraction for 33 years. The ground rent payment that went out annually, the name on the trust documents that most homeowners had never looked at carefully enough to notice. Mitchell Greer had spent 9 years as the visible authority in this community, while I'd been the invisible one. The meeting room was full, standing room at the back. 211 residents, by Margaret Chen's count. A Pinecrest Commons homeowner who'd organized the meeting logistics and become, in the 2 weeks since the community notice had gone out, the de facto information clearinghouse for residents trying to understand what was happening. I stood at the front of the room and spoke for 12 minutes. I explained the ground lease structure in plain language. I explained my family's ownership history, my grandfather's 1951 purchase, my father's 1989 development agreement with Harold Stern, the trust's continuous ownership through the present. I explained that 215 of the households in this room had leases in good standing and had nothing to fear from the current proceedings. And I explained what Mitchell Greer had done. The room was very quiet during that part. When I finished, a man in the second row, a retired teacher named Harold Washington who'd lived in Pinecrest Commons for 22 years, raised his hand. "Ms. Vance, we've been paying HOA dues for 30 years. We've been trusting the board to manage this community honestly. Did any of them, any of the board, any of Mitchell's predecessors, did any of them know about the ground lease and not tell us? The ground lease was disclosed at every real estate transaction through the title process," I said. "It's in every homeowner's closing documents. Most people don't read their closing documents carefully enough to understand the distinction between structure ownership and ground lease. That's not the HOA's fault, and it's not yours. It's a complexity of the development structure that should have been explained more clearly over the years. But Mitchell knew. Mitchell Greer has been a commercial broker for over 20 years. He understood the ground lease structure. He understood that the HOA did not own the land. He recorded a deed anyway." Another silence. Margaret Chen. "What happens to his house?" Mr. Greer's ground lease has been assigned to Meridian Land Capital. Meridian will pursue the enforcement process, termination of the lease based on material breach. If the lease is terminated, Mr. Greer will own his structure without a right to occupy the land beneath it. His mortgage lender will need to assess their collateral position, which means his mortgage gets called. That is a likely consequence, yes. The room processed that. A woman near the back. He tried to sell our land, the land all of our houses are sitting on, to a developer, and he was going to keep the money. That is what the evidence indicates. The room was quiet for a long moment. Then Harold Washington spoke again. Ms. Vance, I want to ask you something directly. You've owned this land our whole time here. You could have been more visible. You could have made sure we understood the structure. Why now? It was the right question, the honest question. Because I was a passive ground lessor, I said. I received my ground rent. I assumed the development was operating honestly. I should have established direct communication with this community years ago. What happened, what Mitchell Greer was able to do, was possible in part because the ground lessor was invisible. That changes today. The meeting ran for 2 more hours. Mitchell did not attend. He was, according to Robert Finch's office, unavailable. 3 days after the community meeting, Mitchell called Finch with the question he apparently couldn't stop returning to. Finch told him what he'd told him in April, the same answer, the same facts, unchanged by repetition. She sold my home, Mitchell said. She sold the land beneath it, Finch said, to a company that does nothing but collect ground rent and enforce leases. There's a difference. What's the difference? Finch had been a commercial litigator for 24 years. He delivered difficult assessments to clients in situations ranging from the merely bad to the genuinely catastrophic. He developed, over those years, the ability to state hard facts without either softening them into false comfort or sharpening them into cruelty. About $340,000, he said, and a very unpleasant next 18 months. The indictment came down on June 18th. The Georgia Attorney General's office had moved with a speed that reflected, Catherine told me, the quality of the referral documentation. When a criminal referral arrives with 47 pages of organized evidence, certified corporate records, a complete title chain, financial documentation, and a timeline that constructs itself without requiring prosecutorial interpretation, the AG's office can move from referral to grand jury presentation in weeks rather than months. The grand jury had been seated in May. The indictment was returned June 18, 2024. Mitchell Allen Greer, 4 counts. Count 1, deed fraud, under Georgia Code Section 16-9-1. Executing and causing to be recorded a deed instrument purporting to convey real property, specifically 1,800 acres of Harmon County land owned by the Vance Family Land Trust, with knowledge that the grantor held no title to the property and with intent to defraud the true owner. Count 2, wire fraud, under Federal Statute 18 U.S.C. Section 1343, using electronic communications, emails, digital documents, electronic proposal submissions, in furtherance of a scheme to defraud, specifically the communications with Apex Growth Partners in connection with the attempted sale of fraudulently claimed land. Count 3, attempted real estate fraud. The Apex Growth Partners development proposal, 340 acres, $8.4 million, constituted an attempt to complete a real estate transaction through fraudulent misrepresentation of ownership. The attempt had failed due to Apex's title examination, not due to any withdrawal by Mitchell Greer. Count 4, breach of fiduciary duty. Mitchell had served as a fiduciary to the 220 households of Pinecrest Commons in his capacity as HOA president. He had used that position to execute a fraudulent transaction on land the community depended on, without disclosure to the board or residents, for his personal benefit. Derek Allen Greer, 2 counts. Count 1, participating in deed fraud. Derek had incorporated Creston Land Partners, LLC, 11 months before the fraudulent deed was recorded. He had served as the grantee entity's sole member, accepting the fraudulent conveyance and participating in the subsequent Apex development proposal as the purported landowner. Count 2, operating a fraudulent real estate scheme. The Creston Land Partners LLC structure, a shell company formed for the express purpose of receiving fraudulently transferred land and attempting to leverage it for commercial sale, constituted a fraudulent real estate scheme under Georgia law. Catherine read me the indictment counts over the phone. I listened without interruption. When she finished, I said, "The civil suit. Ready to file. Do you want to move this week?" Today. The civil complaint was filed in Harmon County Superior Court on June 19th, one day after the indictment. The timing was deliberate. An indictment is not a conviction, and I was careful to ensure the civil complaint stood entirely on its own documented facts, rather than relying on the criminal proceedings. But the parallel filing sent a message about the comprehensiveness of what Mitchell was facing. Criminal exposure on one track, civil liability on another, both moving simultaneously. The complaint had 4 counts. Count 1, fraudulent deed recording and cloud on title. Mitchell had recorded a deed that placed a fraudulent claim on the Vance Family Land Trust's property in the public record. That fraudulent recording constituted a cloud on title, an encumbrance that impaired the trust's ability to refinance, sell, or otherwise transact on its property. Damages: $180,000, representing the costs of the quiet title action, the title examiner's work, and the economic impact of the cloud during the 18 months it had remained on record. Count 2, attempted conversion of trust property. The Apex Growth Partners proposal had represented an attempt to sell 340 acres of the trust's land for $8.4 million. The measure of damages for attempted conversion of property is not limited to actual loss. It includes the value of what was attempted to be taken. Based on the $2.3 million stated consideration on the fraudulent deed and the $8.4 million Apex proposal value, Catherine had calculated a reasonable damages figure of $460,000, representing the trust's loss from the attempted conversion and the economic harm of the fraudulent scheme. Count 3, punitive damages for intentional fraud on recorded title. This was the count that carried the weight of the case. Georgia law allows punitive damages in cases of intentional, willful, malicious, or fraudulent conduct. Mitchell had not made a mistake. He had not acted negligently. He had executed a multi-step scheme over a period of years, incorporating a shell company, recording a fraudulent deed, developing a commercial proposal, conducting negotiations with a developer, all with full knowledge that the property was not his to sell. The intent was documented. The premeditation was documented. The scope of the attempted gain was documented. Punitive damages requested: $920,000. Count 4, attorney fees and costs under Georgia's bad faith litigation statute. Total demand: $1,580,000 plus fees and costs. Robert Finch filed Mitchell's defense response in August. It was 43 pages. Catherine reviewed it and called me with her assessment. He's arguing implied authority. The theory is that the HOA, as the governing body of the community, had implied authority to manage the community's land assets, including the authority to take legal action to clarify or establish the community's relationship to the underlying land. Implied authority to sell land they don't own. That's the theory, dressed in more careful language, but yes. What's your read on how Judge Harrison receives that? Judge Harrison has been on the Harmon County bench for 16 years. He's reviewed the title chain. He's seen the 1951 recording, the 1989 development agreement, the trust transfer. He's a property law specialist. She paused. My read is that he receives it the way any judge with 16 years of property experience receives an implied authority argument with no documentary foundation. The preliminary hearing on Mitchell's motion to dismiss was September 9th. I sat in the gallery. I hadn't planned to attend every hearing. The case was Catherine's to manage, and my presence wasn't legally necessary. But this hearing felt like one I needed to witness, not for evidentiary purposes. For the same reason I'd kept my grandfather's deed abstract on my desk since February, to stay connected to the full shape of what was happening and what it meant. Robert Finch presented the implied authority argument for 22 minutes. He was thorough and organized. He cited Georgia HOA governance law. He cited cases involving community association authority in planned developments. He constructed the most reasonable version of his client's theory that the available legal materials could support. Judge Gerald Harrison listened without interruption. When Finch finished, Judge Harrison looked at the case file. He was a compact man in his early 60s, with the unhurried manner of a judge who'd seen enough property disputes to recognize the ones that turned on documents rather than arguments. "Mr. Finch," he said, "your client's defense rests on the theory that the Pinecrest Commons Community Association had implied authority to manage community land assets, including, under your theory, the authority to execute a deed conveying those assets." "Yes, Your Honor. The Vance Family Land Trust has owned this property since 1951. He set down the file. "Show me the document giving the HOA authority to sell it." Finch had prepared for this. "Your Honor, implied authority by definition doesn't require a specific document. It derives from the nature of the relationship between the parties and the reasonable expectations of community governance." "Mr. Finch," Judge Harrison's voice was patient and entirely final. "The plaintiff's family has owned 1,800 acres of Harmon County land for 73 years. The ground lease development agreement executed in 1989 is in evidence. It contains no grant of authority to the HOA to convey, encumber, or take legal action affecting the trust's title. The individual ground leases are in evidence. They contain no such grant. The HOA's own governing documents are in evidence. They contain no such grant." He paused. "Implied authority cannot be implied from a complete absence of any authority. Show me the document." "Your Honor, the community's 30-year governance history is a governance history over the residential structures and common areas within the development, not over the underlying land." He set down the file. "Mr. Finch, the motion to dismiss is denied. We'll proceed to the damages phase." The damages hearing was October 14th. 2 years to the day from the date Mitchell had recorded his fraudulent deed. I don't know if he noticed the date. I did. Judge Harrison reviewed the damages evidence for 4 hours. Catherine presented the cloud on title calculation, the attempted conversion damages analysis, and the punitive damages evidence, the full documentation of Mitchell's premeditation, the timeline from Creston Land Partners Incorporation through the Apex proposal, the board resolution signed by 4 people who trusted him, the 220 households who'd been managed for 2 years in ignorance of what their president had done. On October 28th, Judge Harrison entered the civil judgment. Count 1, $180,000. Count 2, $460,000. Count 3, punitive damages, $920,000. Count 4, attorney fees and costs, $87,400. Total judgment, $1,647,400. Catherine called me from the courthouse parking lot. "Full amount on all counts. He awarded the full punitives, Eleanor, every dollar." I was in my office. The park outside was in full fall color, the particular red and gold of Atlanta October. The trees doing what Georgia trees do when the light changes and the temperature drops, and the whole city briefly becomes beautiful in a way that feels like it's addressing you personally. Did he write on the punitives? 2 pages. I want to read you the final paragraph. I heard paper. "The evidence before this court establishes a scheme of extraordinary deliberateness. The defendant incorporated a vehicle for fraud 11 months before executing the fraudulent conveyance. He managed a community of 220 households for 2 years after recording that conveyance, without disclosing it to a single one of them. He attempted to complete a commercial sale of fraudulently claimed land for $8.4 million. He failed only because a title examiner did the work his own conscience did not. The plaintiff's family has owned this land since 1951. Through times in this state when black land ownership was not merely legally contested, but physically threatened. That the defendant chose this property, this ownership history, and this family as the target of his scheme does not go unnoticed by this court. The punitive damages awarded reflect not only the severity of the conduct, but the significance of what was attempted to be taken. The office was very quiet. "He wrote it into the record," I said. "He wrote it into the record." I looked at the park. My grandfather at the 8th Bank, 20 years of savings and a loan from the one institution willing to say yes. A deed recorded on April 3rd in Harmon County, Georgia, when Georgia was a place where that deed required not just money, but courage. 73 years later, a judge had written 2 pages explaining why the man who'd tried to take it needed to pay $920,000 in punitive damages. Meanwhile, Meridian Land Capital had been doing what Meridian Land Capital does. Mitchell's ground lease termination had been formally executed in August. after the preliminary motion hearing confirmed there was no viable defense. Meridian had filed the termination notice, provided the required cure period, received no response, and executed the termination. Mitchell Greer owned a structure at 14 Pinecrest Commons Boulevard. He no longer had a legal right to occupy the land beneath it. His mortgage lender, a regional bank that had extended a $520,000 loan against a home they'd valued at $780,000, had been notified of the ground lease termination in September. Their collateral assessment had taken 3 weeks. The conclusion was what it always was in these situations: a structure without a lot, without a ground lease, without any legal right to remain where it stood. Appraised value as a relocatable structure, $210,000. Outstanding mortgage balance, $498,000. The bank called the loan in October. The 3 allied board members had settled in July. All 3 had retained separate counsel after the indictment. All 3 had concluded that cooperation was less expensive than resistance. Their settlements ranged from $47,000 to $89,000, reflecting their varying degrees of participation in the authorization resolution and the subsequent concealment. The 4th board member, a man named Victor Crane, who'd been on the Pinecrest Commons board for 7 years and had signed the authorization resolution with, he maintained, no understanding of what he was authorizing, had hired an aggressive Atlanta litigator and prepared to fight. His trial date was set for February 2025. It lasted 4 days. The jury deliberated for 6 hours. Victor Crane lost on all counts. Mitchell Greer was convicted on March 3, 2025. The criminal trial had taken 6 days. The prosecution's case was the documentation, the same documentation Catherine and I had assembled beginning in February 2024, presented now to a jury of 12 Harmon County residents who had spent 6 days watching a prosecutor walk methodically through a timeline that constructed itself without requiring interpretation. November 2021. Creston Land Partners LLC Incorporated. Sole member, Derek Greer. October 2022. Fraudulent deed recorded. Grantor, Pinecrest Commons Community Association. Grantee, Creston Land Partners LLC. Consideration, $2.3 million. Never paid. February 2023. Creston Land Partners approaches Apex Growth Partners with a proposal to develop 340 acres of Vance Family Land Trust property for $8.4 million. Mid-2023. Apex withdraws after title examination reveals the obvious. October 2023 through February 2024. Mitchell Greer continues serving as HOA president, conducting community meetings, collecting dues from 220 households, telling no one. February 2024, Eleanor Vance's title company runs a routine ownership search. The jury had deliberated for 8 hours. All 4 counts. Guilty. Derek Greer had pleaded guilty to both counts in January, a negotiated plea that had secured him a reduced sentence in exchange for full cooperation with the prosecution of his father's case. His cooperation had included producing emails, text messages, and internal Creston Land Partners documents that established the timeline of the scheme with a precision the prosecution couldn't have achieved otherwise. A son testifying against a father. I didn't find satisfaction in that specific element. It was a consequence, not a goal. The downstream of decisions Mitchell had made when he'd involved his son in a scheme built on 73 years of someone else's family history. Mitchell's sentencing was April 22nd, 4 counts, Georgia mandatory minimums for deed fraud and wire fraud. The judge, not Harrison, this was the criminal division, reviewed the full scope of the scheme, the premeditation, the duration, and the 220 households whose trust Mitchell had held and exploited. 7 years. Eligibility for parole after 4. Robert Finch had appealed the civil judgment while the criminal proceedings were ongoing. The appeal had been denied in its entirety in January. The $1,647,400 judgment stood. Mitchell's assets, the structure at 14 Pinecrest Commons Boulevard, sold in a short sale for $187,000 after the mortgage call. His commercial brokerage business, valued by a court-appointed assessor at $340,000. Personal financial accounts and retirement funds subject to judgment collection, had satisfied approximately $680,000 of the civil judgment. The remaining $967,400 would follow him out of prison. The fraudulent deed was formally expunged from the Harmon County Public Record on April 29th, a Tuesday morning, 7 days after Mitchell's sentencing. Judge Harrison signed the expungement order himself. The clerk annotated Deed Book 847, page 223, with a single stamped notation, Void ab initio by order of Harmon County Superior Court, April 29, 2025. Catherine sent me a photograph of the annotated page. I printed it and put it in the trust file, behind my grandfather's original 1951 deed. The new ground lease agreements took 4 months to negotiate and document. I'd begun the community outreach in April 2024, the same month the Meridian assignment was executed, the same month the quiet title action was proceeding. I hadn't waited for the criminal proceedings to conclude. The 215 uninvolved households deserved clarity as quickly as I could provide it, independent of whatever happened to Mitchell in the courts. Margaret Chen had been the organizing voice on the community side, a retired financial analyst who'd applied the same precision to understanding the ground lease structure that she'd spent 30 years applying to corporate balance sheets. She'd formed a homeowner committee of 11 residents. They'd retained a property attorney in Nashville, a deliberate choice, an outside voice with no connection to the Harmon County legal community or to any of the parties in the litigation. Their attorney had reviewed my proposed lease terms and come back with 14 comments. Catherine and I had addressed 12 of them entirely and compromised on 2. The resulting agreement was 31 pages, longer than the original Stern-era leases because it was more complete. The structure was straightforward. Each household owned their building. The Vance Family Land Trust owned the land. Annual ground rent was set at current Harmon County market rate for ground lease parcels of comparable size, a calculation that the homeowner committee's attorney had independently verified using 3 comparable ground lease developments in Georgia. The term was 50 years, with renewable options on terms set by a formula tied to assessed land values with a cap on annual escalation. Not because 50 years was necessarily the ideal term, but because 50 years gave every homeowner in Pinecrest Commons a ground lease that would outlast their mortgage, outlast their likely tenure in the home, and provide the kind of long-term security that the original Stern-era leases had never explicitly offered. The leases were title insured. Every household received a title insurance policy covering their leasehold interest. The first time any Pinecrest Commons homeowner had held title insurance on their ground lease position. And each lease contained a provision that had not existed in any prior Pinecrest Commons document. A plain language summary on page 1, before the legal terms began, explaining in 3 paragraphs exactly what the homeowner owned, what the trust owned, and what the ground lease relationship meant in practical terms. No homeowner who signed this agreement would be able to say, 30 years from now, that they hadn't understood the structure. 212 of the 215 uninvolved households signed by August 2025. 3 households had declined, 2 who were planning to sell and didn't want the long-term commitment, 1 who had retained an attorney and was negotiating separate terms. Catherine was handling the remaining negotiation. It would resolve. The fraudulent deed was gone from the record. The new leases were recorded. The ground lease structure of Pinecrest Commons was, for the first time in 33 years, fully documented, fully disclosed, and fully understood by every party to it. My granddaughter visited in September. Amara was 19, in her first year at Emory Law, a decision she'd made at 16 and never reconsidered. She had her great-grandfather's steadiness and her mother's precision, and a quality of attention that made you feel, when she was listening to you, that she was filing what you said in a place she'd be able to retrieve it 30 years later. She'd followed the Pinecrest Commons situation from the beginning. I'd kept her informed, not because she needed to be. She was 19, she had law school, but because the land was part of her inheritance, and she had a right to know what had happened to it and how it had been defended. We drove out to Harmon County on a Saturday morning in September. The 1,800 acres in September. Georgia September, when the heat has finally broken and the light comes at the low angle of early fall, and the fields have the particular gold of the end of summer. The Pinecrest Commons development was visible at the eastern edge of the property, rooftops through the tree line, the quiet of a Saturday morning in a residential community that was, for the first time in 2 years, operating without the weight of what its president had done. We stood at the western boundary, the farthest point from the development, where the land was still working farmland, the same soil my grandfather had farmed for 15 years before the development came. Amara looked at it for a long moment. "Grandma," she turned to me, "why did your grandfather buy this much land in Georgia in 1951? It must have been almost impossible." I thought about how to answer that. I'd thought about it many times over the past year, not because the answer was complicated, but because the answer deserved to be said precisely. "It was," I said. "He was told no by 7 banks. 7. He drove to each one and sat across from a loan officer and stated his case and was told no. Some of them were polite about it, some of them weren't." I looked at the field. "He found the 8th bank, a black-owned institution in Atlanta. The loan officer there was a man named Charles Worthy, who'd been lending to black farmers and business owners in Georgia for 20 years. He reviewed my grandfather's financials, reviewed the property, and said yes." Amara was quiet. My grandfather had been saving for 20 years. He was 43 years old in 1951. He'd spent his entire adult working life accumulating the money for this land. He scraped together everything he had and borrowed the rest and bought 1,800 acres of Harmon County, Georgia farmland on April 3, 1951, and recorded the deed the same day. People told him he couldn't. People told him a black man couldn't hold land like that in Georgia in 1951. Not that much land, not in Harmon County. People told him the land would find a way back to someone else eventually, that there were too many forces aligned against that kind of ownership lasting. Amara looked at the 1,800 acres. What did he say? I looked at the field, the gold September light, the tree line where the Pinecrest Commons rooftops were just visible, the soil my grandfather had farmed, that my father had developed carefully and partially, that I had inherited and defended and would pass to my daughter and eventually to the young woman standing beside me, who was going to be a better attorney than I'd ever been. He said the deed would outlast the opinion. Amara was quiet for a long moment. "It did," she said. "It did." We stood at the western boundary of the Vance family's 1,800 acres for a while longer, not speaking, letting the September morning do what September mornings in Georgia do when you give them enough quiet to work in. Then Amara asked, "Is this what property law feels like, when it works the way it's supposed to?" I thought about the February morning in my office, the title examiner's careful voice, the fraudulent deed on my screen, the 40 years of practice that had prepared me to understand in 40 minutes what Mitchell Greer had done and what it meant, the 18 months of patient, methodical work that had followed. "Property law works the way it's supposed to when the documentation is clean," I said. "When someone did the work of recording the deed, maintaining the chain, keeping the records, doing all of it correctly for 73 years. I paused. Mitchell Greer thought he could record a fraudulent deed on my family's land because we were invisible, because the trust was passive, because a black woman in Atlanta was an abstraction to him, a name on a ground rent check, not a person with 40 years of legal training and 73 years of clear title. He found out differently. He found out differently. We walked back to the car through the September field. The Vance family had owned 1,800 acres of Georgia land since 1951. In October 2022, the HOA president of the community built on that land had recorded a fraudulent deed transferring it to his son's shell company. He had then attempted to sell 340 of those acres to a commercial developer for $8.4 million. The attempt had failed because a title examiner had done his job correctly. The fraudulent deed had remained on the record for 18 months until a routine title review found it. Eleanor Vance had not called the HOA when she found it. She had called her attorney. 18 months later, Mitchell Greer had a criminal conviction on 4 counts, a 7-year sentence, a civil judgment of $1,647,400, a ground lease that had been sold to an enforcement firm, a structure he'd been forced to sell for $187,000, and a real estate brokerage assessed and seized toward a judgment he would spend years trying to satisfy. The fraudulent deed had been expunged from Harmon County Deed Book 847. The Vance Family Land Trust Deed, recorded April 3, 1951, by Raymond Vance Sr. at the 8th Bank, after 20 years of savings and a loan from the one institution willing to say yes, was still recorded exactly where it had always been. Mitchell Greer had found out what 73 years of clear title looks like when the owner finally decides to use it. The deed had outlasted the opinion. It always had.